For more on the upcoming impeachment hearings, where the road leads from here, and a look at the 2020 Democratic race, special correspondent Jeff Greenfield joins us now from Santa Barbara. Tomorrow is, well, I guess another big-ish day. I mean, we've had a lot of big days in the past couple of weeks. What happens?
Well, unlike last week when constitutional scholars were debating the law, we're going to hear from lawyers from the Intelligence Committee and from the Judiciary Committee. The Democratic lawyers will present the case, the factual case that they assert for impeachment, abuse of power, possibly bribery, and the Republican lawyers will present the counterargument that the president did nothing untoward. He was simply exercising his legitimate authority.
I've got some breaking news for you, and it's still unfolding. The Trump Justice Department has just released new FBI documents that were missing from the earlier Epstein files. Right now, MSN Now is sifting through these new files carefully. We want to make sure we get everything right before sharing any details. Here's what I can share at this moment. Among these new documents, there are 3 FBI 302 memos. These are basically notes that FBI agents take to summarize interviews with witnesses. What's interesting is that these notes include unsubstantiated allegations of sexual assault against Donald Trump. The memos detail an account from a woman who accused Trump and Jeffrey Epstein of assaulting her when she was a teenager, which was quite some time ago. One of these documents mentions that the woman was asked if she felt comfortable discussing her interactions with Trump. She seemed hesitant, questioning what the point would be of sharing her experiences now, especially given the slim chance that anything could be done about it. The documents are filled with redactions, which makes some of the information harder to digest. Trump has consistently denied any wrongdoing related to Epstein. But now, let me tell you about a moment that could be quite significant for his legal situation. It's interesting to note that this wasn't coming from a fierce prosecutor who has been gunning for him for years, or from a researcher on the opposition side with their own agenda. Instead, it was Kash Patel, someone Trump previously highlighted as a key ally and defender. Patel was meant to be the witness who would support Trump's claim about all the documents at Mar-a-Lago being declassified. Supposedly, there was even a standing order that made the entire case against Trump fall apart. However, under the influence of immunity, which meant he had to testify without his Fifth Amendment rights, Patel ended up giving evidence that didn't back up the claim about any broad standing order for automatic declassification. His testimony now aligns more with what the prosecutors are saying rather than the defense. Sensitive Snorts records, they've remained classified. So here's the thing. The story that Donald Trump had been sharing publicly and the narrative that Kash Patel pushed in his media interviews to clear Trump's name took a pretty big turn when Patel found himself under oath. When he was in front of the court, he had to face the fact that lying could land him in serious trouble with federal perjury charges. It's honestly hard to believe he said that out loud. The difference between what Patel claimed casually in the media and what he stated while under oath reveals a lot about the credibility of the declassification defense he'd been touting. This defense seemed solid as long as the folks who knew the truth could speak freely and without consequences. But once Patel was bound by the truth, unable to use immunity or plead the Fifth, the defense began to crumble.
House Democrats shut down a fellow member's latest attempt to impeach President Trump. 23 of those Democrats joined Republicans in voting down Texas Congressman Al Green articles accusing Trump of abuse of power. Here's Al Green yesterday.
If ever there was a person who ought to be impeached, it's Donald John Trump. This president is a reckless, ruthless, lawless person who doesn't deserve the title of president.
There's a lot happening with the FBI interview forms, often called 302s, which we've been sifting through, especially those connected to victims of Jeffrey Epstein and Ghislaine Maxwell. We already caught a glimpse of one interview involving the same accuser linked to both Trump and Epstein in those documents. We know there are a total of 3 other victims that also need to be looked into. In fact, MS Now, NPR, and independent journalist Roger Senberger have been working together to shed light on these important documents. Just to be clear, it's crucial to differentiate between the elements in the videos surrounding this story. Laying out the fictional parts helps make the facts I share feel more reliable. So when you come across YouTube videos with titles suggesting Trump is acting wildly or losing it, just keep in mind the reality behind those flashy headlines. So here's the scoop. Kash Patel has testified against Trump, which really isn't great news for the former president. Patel admitted that some pretty serious crimes were just commentary pieces. Now, while people love to dramatize how Trump reacted, there are no actual recordings of him screaming at Patel in a courtroom or during some Oval Office showdown. I won't mislead you into thinking there's footage out there. That's just not the case. What is documented, however, is far more crucial and legally significant than any imagined shouting match. The immunity grant and Patel's testimony reveal a lot about Trump's defense regarding the classified documents issue. This is where it gets interesting. Patel's compelled testimony is seriously damaging, and despite the viral thumbnails making a big deal out of a supposed betrayal, the situation is legitimate even without the confirmed shouting. The legal reality is already tough enough on its own. Patel was no mere bystander or casual acquaintance in this mess. He was seen as the go-to guy who could confirm Trump's claims about a standing declassification order. When questions arose about how classified documents landed at Mar-a-Lago, Patel's name kept popping up as the one who could clarify how it all went down. Specifically, that Trump had supposedly issued an order before leaving office that automatically declassified anything he took with him. This standing order defense is the heart of Trump's legal argument, suggesting the documents weren't classified when they were at Mar-a-Lago and that Trump had a solid legal reason for having them. However, that argument is fundamentally flawed. Patel was meant to solidify this narrative under oath. Instead, the Department of Justice decided to grant him use immunity, which means his testimony can't be used against him personally. But now he's also unable to provide the critical backing that Trump needed. So here's the scoop. Kash Patel had to take the fifth, but ended up answering every question truthfully, which is a big deal because if he didn't, he could face serious consequences. When he shared his sworn account, it surprisingly aligned more with what the prosecutors were saying rather than the story he had been pushing in interviews. It turns out those sensitive records stayed classified, and there wasn't any formal declassification process going on. Now, this is pretty wild because Patel, the key witness that Trump's team was relying on to support their defense story, ended up giving prosecutors a version that fits their theory more than Trump's. Basically, the inside man became a bit of a liability. The implications of that flip, plus the whole immunity-driven situation, are going to stick around for this case as long as it lasts. Let's break this down a bit. Patel's testimony has several important facets worth discussing. First off, let's talk about how use immunity operates and how it can turn a loyal witness into someone compelled to testify. Specifically, what Patel revealed during his grand jury testimony is crucial and pretty damaging to the defense's standing declassification argument. The whole perjury lock adds another layer to this, especially since his testimony is now set in stone under oath. When we look at the overall context of the classified documents case, it shows just how legally shaky the defense theory has always been. Plus, it's politically significant that Trump's main documents defender didn't back him when it was most critical. To understand the weight of Patel's testimony, we first need to grasp how use immunity works. This legal tool is something federal prosecutors use when they need a witness to testify. Yet that witness would otherwise use their Fifth Amendment right against self-incrimination. The Fifth Amendment is there to protect folks from being forced to give testimony that could land them in hot water during a criminal case. With use immunity, the government agrees that the specific testimony the witness gives can't, snorts, be used against them later if they end up in trouble. The catch here is that by accepting this immunity, the witness has to ditch their right to take the fifth on the questions covered by it. They've got to answer truthfully, and everything they say is considered sworn testimony, which is a big deal because it's under penalty of perjury. It's a bit of a clever legal strategy, but also a tricky one. From a prosecutorial angle, giving immunity to a witness like Kash Patel puts him in a tough spot. Before immunity, he could just take the fifth on any important question and not add anything to the case. But once he gets immunity, every response he gives is sworn in and locked in. If he says something that contradicts what he said before, he could be looking at a potential perjury charge if it turns out to be false. The Justice Department didn't grant Patel immunity as a favor. It was a strategic move to push him into a corner. If he lies to protect Trump, it could come back to bite him in a way that Trump can't just pardon him for. Since the immunity decisions are made by prosecutors who aren't involved in the case anymore under the current administration, once he talks, his testimony gets recorded in the grand jury, no matter what happens with the case later. What makes this immunity grant particularly crucial is what Patel ultimately revealed during his testimony, which has been analyzed by legal experts and reporters covering the situation. There's this theory floating around that prior to leaving office, Trump issued a broad standing order automatically declassifying any documents he took with him as president. If this theory holds water, then the documents at Mar-a-Lago wouldn't be classified because Trump had already used his constitutional authority to make them unclassified. It's a bold legal claim, but whether it holds up as a defense really hinges on having credible witnesses confirm that the order existed and applied to the specific documents in question. Patel was uniquely positioned to back this up. He had a close relationship with Trump during that critical time and had been talking about the existence of that order in interviews. His confirmation under oath would have been solid evidence for this defense. Instead, his sworn testimony lines up with what the prosecutors are saying. Sensitive records remained classified, and there wasn't any formal declassification process used. Those 2 points from his testimony go directly against the main claims of the standing order defense, that the records were declassified and that Trump's method was legitimate. It's honestly hard to believe he said that out loud. When your own witness under oath places those details in doubt, it really shakes the foundation of that whole defense strategy. So here's the deal with Kash Patel and his grand jury testimony. He initially had media interviews where he talked about this standing order idea, suggesting that Trump had the right to keep the documents he had. But here's the catch. Those interviews weren't sworn testimonies, so they weren't officially binding. They were just him trying to shape the story around the case as a Trump supporter. Now, after his grand jury testimony, everything changes. What he said there is now on the record, and he put that under penalty of perjury. If Patel decides to change his tune later on and goes back to the media, contradicting what he said under oath, he could face some serious consequences for perjury. Legal experts have pointed this out after his immunity was granted. His testimony is sealed in, and that makes it pretty risky for him if he tries to shift his story to protect Trump down the line. It's honestly hard to believe he thought he could play both sides. Patel has to stick to the same narrative in both settings. What he said under oath and what he says in public must align. The story he went with under oath doesn't support the standing order idea. Instead, it aligns with the prosecution's version, which discusses the classified records. Talking about the standing order defense, it has always been legally shaky. Understanding its weaknesses helps clarify why Patel's testimony isn't just a hassle, but truly damaging. There are two major legal hiccups with this standing order theory that don't rely on any witness's claims. First, there's the legal process for declassifying national security info. Declassification isn't just about what the president thinks or says, it's a whole procedure guided by executive orders. When it comes to declassifying documents, there are federal regulations that really spell out what needs to happen. There's a whole process that requires specific documentation, notifying the agencies where the classified info came from, and keeping records that can be audited to track what was declassified, when it happened, and by whom. If there's a standing order that isn't documented the right way, hasn't been communicated to the necessary agencies through the appropriate channels, and isn't reflected in the required record keeping, that doesn't count as legally effective declassification according to the current rules. The defense is asking courts to believe that an undocumented, uncommunicated, and unrecorded presidential intention could be legally binding for declassifying certain documents. Constitutional and national security law experts have found this argument pretty hard to back up given the existing regulations. And there's also the Presidential Records Act to consider. Even if the declassification claim holds up, the documents in question still need to follow the rules under this act regarding how presidential records should be handled and returned. So just because there's a declassification argument doesn't mean it clears the situation with the Presidential Records Act. It only tackles the specific counts related to classified information. It's honestly hard to believe they tried to build a defense on this shaky ground. The theory that Kash Patel was meant to back up under oath has snorts serious legal issues that make it pretty flimsy. Even with top-notch witness testimony, if no one backs up the declassification order and the best-positioned witness instead provides a version of events that contradicts the defense theory, the legal weaknesses are glaring both in terms of evidence and the principles involved. Now, shifting gears a little, let's talk about why the Patel situation matters politically. While the legal details around immunity and perjury are significant, what really stands out is how this plays into the bigger picture of how Trump's team is dealing with the classified document situation as they eye a second term. Kash Patel wasn't just any old witness in the document case. He was a key player in the Trump defense narrative about the documents in the media. His role was to be the go-to guy whenever Trump's operation needed someone to say, here's someone who was there who knows what really went down and can confirm our declassification story. So there's this whole situation where someone was pushing for a theory related to a standing order. This was a way to manage the public's view on a document's case while everything was still unfolding in the courts. When prosecutors decided to give this person immunity and make him testify before a grand jury, it wasn't just about getting one person's insight. It was a direct shot at the narrative that Trump's team had been using as their public story. Suddenly, the person who had been a solid anchor for their narrative found himself in a legal bind, having to defend that narrative under oath, where lying could lead to serious consequences. Then, when he went to testify, things didn't really match up with what they were hoping for. His story aligned more with what the prosecutors were saying than with the standing order theory their side had been relying on. This pretty much caused their whole narrative to fall apart, which also messed with their legal strategy. It's a tough spot. What was meant to be a witness saving the defense ended up failing to do so when it really counted. The words he shared while testifying are now part of the prosecution's arsenal for anything related to the documents case. Now, about the loyalty angle here, it gets interesting. Patel's situation fits into this bigger picture of Trump loyalists realizing that their loyalty isn't a shield against federal legal maneuvers. He didn't just waltz into that grand jury room and turn on Trump willingly. No, he was basically forced into it, losing his Fifth Amendment rights thanks to the immunity deal that left him no choice but to speak the truth or risk perjury. This really tested loyalty, but not in a way where he could just choose to stand by Trump. It's a legal setup designed to make sure personal loyalty doesn't interfere with sworn testimony. So when his testimony leaned towards what prosecutors had to say, instead of backing up the defense's claims, it doesn't mean he abandoned Trump in some morally loaded way. It shows that under a legal framework where telling the untruth could land someone in hot water, the calculations around loyalty shift quite a bit. It's almost comical, really. This is exactly what immunity agreements are meant to do. So here's the scoop on what's been happening with Trump and his crew, particularly around Kash Patel's situation. It's pretty clear that relying on loyal supporters as a safety net for legal troubles isn't quite as foolproof as they thought. The expectation was that those who have been backing Trump's narrative publicly would stick to it when they were asked to testify under oath. But then Patel came forward, and his testimony has really shaken things up. It's now in the prosecution's hands and part of the grand jury record. No matter what Patel or Trump might say later on, or how they might try to spin their relationship, let's break it down a bit. First off, it's crucial to understand how use immunity works. It's not just a friendly gesture or some kind of favor. It's more like a strategic tool for prosecutors to push hesitant witnesses to either give honest testimony or face serious consequences if they don't. When the Department of Justice decided to grant Patel this immunity, they effectively took away his Fifth Amendment protection. He was supposed to help support that standing order narrative. But once that shield was gone, he had a major decision to make: tell the truth under oath or risk facing perjury charges. The prosecution didn't just need Patel to come forward willingly with info. They wanted to put him in a position where lying under oath would have real legal implications. This immunity setup made that possible, and the answers he provided aligned with what the prosecutors wanted, not with the defense strategy they had in mind. Now, on to the second point, we have what's called the perjury lock. This legal concept means that Patel's testimony is more than just an annoying statement for Trump's camp. It's a serious legal matter with consequences. It's a game-changer in how this whole situation plays out. So here's the thing. Once something gets nailed down in a grand jury record, it's locked in under penalty of perjury. That means if someone, say Kash Patel, decides to go on the record and then tries to tweak that story later with public statements, he could be opening himself up to some serious trouble. Each statement that goes against what he originally said creates a potential for perjury, and this doesn't just disappear after his time in the spotlight. It carries over into any legal proceedings that pop up in the future. So whether it's a new prosecution after Trump's presidency or civil cases regarding document handling, that sworn testimony is there to haunt him. It's a wild situation. The permanence of that testimony really holds weight in legal terms, locking the narrative down when the stakes are highest. It prevents the kind of story switching that the media might allow. Think about it. Before his testimony, Patel could chat freely about his theory regarding standing orders, adjusting his story as things changed. But once he steps under immunity and testifies, that's it. Those words are part of the official record now, and they don't change. And let's not forget the standing declassification defense. It was already on shaky ground before Patel testified, and now it's even weaker. The legal theories are problematic on multiple levels, from issues with the regulatory process to the absence of any real proof of that supposed order. Courts would still need to deal with those issues totally independent of what any witness might say. Patel's testimony only adds to the pile of problems. The very person who was supposed to back up Trump's claims didn't support them under oath. So we've got both doctrinal and evidential issues popping up simultaneously. It's pretty clear that a defense theory with that many problems is in deep trouble. And this trouble isn't going away anytime soon. It's all documented and locked down, making it immune to the typical narrative management that has helped Trump in the past. So we're looking at Kash Patel and his whole immunity deal, which really shows a big flaw in Trump's legal strategy. The plan hinges on having loyal insiders who can support Trump's narrative both in public and when it comes to legal matters. It's a neat little trick that depends on these insiders using the Fifth Amendment to protect themselves while still backing up Trump's story. But here's where it gets tricky. When immunity comes into play, it really shakes things up. It separates the protection of the Fifth Amendment from the requirement to testify, which means witnesses can avoid personal prosecution, but still have to give their sworn statements. What's wild about this is that every Trump supporter who has been out there spouting a particular version of events could be in the crosshairs just like Patel. The fundamental issue with this loyalty-based strategy is that it relies heavily on these insiders being able to remain silent. But immunity can completely dismantle this whole setup. And this isn't some fancy new tactic. It's a standard tool that prosecutors can use in any federal investigation. The fact that they've applied it to someone as high profile as Patel shows just how vulnerable this loyalty-based narrative really is and how prosecutors can play it to their advantage. So where does that leave us now? It puts Patel, who's been touted as the go-to guy for the story about declassification, in a tough spot. He's got to testify before a grand jury under the threat of perjury. And instead of backing up his old story, he ends up aligning with the prosecutors. Now, that testimony is sealed in the grand jury records, meaning he can't change it without risking a perjury charge, and it'll be available for any future legal proceedings relating to the document's case. Basically, the whole standing declassification defense is now in a weak position, facing both theoretical issues and evidence problems, especially since the main witness has been unable to confirm it under oath. It's interesting to see how loyalty can be so fragile when it comes to legal proceedings. There's this clever legal tool that makes people choose between sticking to a story while under oath or risking perjury charges for lying, and that's exactly what happened here. It's almost like a federal mechanism pushes individuals into a corner. Kash Patel found himself in this tricky spot and ended up making the call that the law practically forced him to make. His testimony is now in the hands of the prosecution, and it's clear that the defense's narrative is looking a lot shakier than it did before he received immunity. Looking ahead, I can't help but think about who might be next. Each time someone else is granted immunity and has to testify, there's this same fraught decision about whether to stay loyal to the narrative or risk facing serious legal consequences. Each new case will only highlight the vulnerabilities that Patel's situation has laid bare for everyone to see. The prosecution is definitely aware of where these weaknesses lie.